Okay, we're on YouTube now. Today is September 6, 2022. It's the 8:30 a.m. civil bench trial, civil motions calendar. My name is Brad Gardner. I'm going to be the presiding judge over this matter here today. Case number is 2020 CM 13436, John Washington versus Landmark Dodge Chrysler. Mr. Washington is present. He's being represented by Attorney Amin. Landmark Dodge is present. They're being represented by Attorney Stone. Miss Amin, would you swear in your witness? And
please raise your right hand, Mr. Washington. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead, ma'am. The second part was present your case.
All right. I have a brief opening, Your Honor.
Yes, ma'am.
On June 1st, 2019, Mr. Washington took his 2012 Jeep Grand Cherokee to Landmark Dodge Chrysler Jeep LLC. The vehicle was overheating. He paid $5,800 for repairs, and said repairs are listed on was to be admitted as Exhibit 1, which is also one of the defendant's exhibits. At the time, the plaintiff received a 2-year unlimited mile warranty. However, the evidence will show in early October 2019, he experienced the same overheating problem again, and he called the defendant and they told him they would charge him to reinspect the vehicle. My client wasn't satisfied with that response, as he had already paid $5,800 and the car was supposed to be under warranty. My client later learned that his car was not repaired as he alleged, which is shown on Exhibit 3 in Palmer Dodge's invoice. They listed what was not done with that vehicle. And the evidence will show that basically that Landmark, the defendant, failed to replace the long block of my client's car. So he took the car back to them on July 24th, and they had his car until August the 19th. Then at that time, they told my client that he needed a new engine, and I don't even think that Landmark inspected the engine at that time. While Landmark was in possession of my client's car, his windshield was cracked as well, and they refused to pay for that repair. And we have evidence and pictures showing that the vehicle was not, the windshield wasn't cracked when he took it to Landmark, but it was cracked when he went to look at his car. So today we are suing the defendant Landmark for breach of contract, negligence, and fraud. And we believe that defendant Landmark is indebted to the plaintiff for damages for $5,800 for the repairs, approximately $3,000 for rental car expenses and storage fees that my client has had to pay regarding his car. And the evidence will also show that the car is still not in drivable condition. It's inoperable, and my client has ended up having to just keep it in storage because he cannot drive it.
Thank you, Mr. Stone. Do you have a brief opening?
Sure, Your Honor. I don't disagree with the first part of what Ms. Amin said. Mr. Washington brought his vehicle to Landmark Dodge with complaints that it was not running. It was towed in. It was determined that the vehicle had overheated due to some failures of components. He was given an estimate to do the repair to what's called a short block, or the top end of the engine. He authorized that repair. The repair was done in a good and workmanlike manner. The next time that Landmark heard from Mr. Washington was about a year later, and that was in July of 2020 when he brought his vehicle back to Landmark. And at that time, he was complaining about a knocking noise. It was determined that the bottom end of the engine was bad and would need to be replaced. Landmark provided him with an estimate of $9,000. Mr. Washington refused or declined to have those repairs made. I think the evidence, Your Honor, will be clear that there has been no breach of contract. Landmark was Landmark offered to repair the top end of the motor. Mr. Washington agreed. Landmark performed those repairs in a good and workmanlike manner, and Mr. Washington paid for those repairs. Landmark performed exactly the service that it was contracted to perform. As far as negligence goes, as I mentioned, Landmark did the repair in a good and workmanlike manner. The bottom end or the bottom part of the motor has nothing to do with the top end of the motor. That will be proven through Mr. Valadez's testimony. And as far as a fraud claim, there's been no misrepresentation whatsoever as far as any of the repairs go or any other communications between Landmark and Mr. Washington.
Mr. Washington, you have a lawyer, sir. You will have the opportunity to speak through your lawyer in this case, but I have to respect the fact that you decided to hire a lawyer.
That's fine.
Okay, Miss Amin, call your first witness.
I call Mr. John Washington Jr.
Mr. Washington, you've been sworn, sir. Miss Amin, proceed.
Mr. Washington, when did you first take your 2012 Jeep Grand Cherokee to Landmark Chrysler?
Sometime in June of 2019.
Okay, would June 1st, 2019 sound about right?
That's around that time, yes.
And when you took your car to them, did you expect them to give you a full diagnostic about everything that was wrong with the car?
No, my car was just overheating, and they referred me to get that process done.
Okay, did you expect them to give you a full diagnostic about all the problems that could be caused, that could cause the overheating?
Yes, I did.
Your Honor, I know we're a little looser with maybe the rules of evidence, but I would just object that counsel's leading the witness.
I'm going to allow foundational type questions, but just so we can move this along. Go ahead, ma'am.
All right. And at that time, did you receive an invoice about repairs from Landmark?
Yes, I did.
And I think Mr. Stone has this exhibit, and I emailed it to Ms. Mary, but we're going to first look at Plaintiff's Exhibit 1.
Okay.
And do you have that document, Mr. Washington?
Yes.
And can you identify that document?
It says, it has the date of June the 13th on the document.
What is the document?
I have the Landmark, the paperwork of Landmark, but it's dated June the 13th. And
Okay, and what does that paperwork show?
it shows that the total invoice is $5,800 and customer hereby knowledge received. I'm still reading all the way down.
And Mr. Washington, to the best of your ability, please respond to the questions that are asked from your lawyer.
Okay, it shows that my vehicle.
Hold on, sir. I'm not done. And if you need to review anything to refresh your recollection, we'll allow you to do that, sir. You just have to say, I don't remember. Your lawyer will point you in the direction of the document that may allow you to refresh your recollection. You get to read the document and then you say, okay, I'm ready. But what we don't do is allow people to simply read from a document. Okay, sir? I know it sounds crazy, but that's just a quirk in the rules of evidence.
So, Mr. Washington, do you recognize the document?
Yes,
Okay, what is the document?
it's a receipt from Landmark indicating the estimate value for fixing my vehicle.
And what was that value on the receipt?
$5,800.
Okay, does it itemize the repairs that were to be done for that $5,800?
To the best of my knowledge, I would say no, because the car wasn't repaired. But for what they said that they did, no, because there's something missing that they did not do correctly.
So,
Can
Mr.
you please
Washington,
answer the question that I'm asking you only, Mr. Washington?
Go
yes,
ahead.
and so, Mr. Washington, just so you understand, when I hear your lawyer ask a question, I'm listening for the answer.
Okay.
But if you go off somewhere else, if she says, well, what were you doing last night? Well, it was raining
got you.
last night, you know.
I got you.
Okay, thank you. Go ahead,
And
ma'am.
may I have a literally a 1-minute recess, Your Honor?
Yes, ma'am.
Okay, please mute your phone, Mr. Washington, and mute your Zoom and answer your phone, please.
Okay.
Well, I don't think it's appropriate for counsel to be talking to the witness while he's under oath in the middle of questioning.
I do understand what you're saying, Mr. Stone. But let's Mr. Stone, if we were in the courtroom and the judge says, I'm gonna take a 5-minute recess, I'm not believing that Miss Amin is going to instruct her client to do anything other than answer the questions that she's asking.
And as an officer of the court, I guarantee you, Mr. Stone, I'm only going to go over the instructions about answering directly that I instructed him with before. I will not discuss any evidence.
Sure,
The
and
judge can put us in a breakout room if he wants to.
I didn't mean to insinuate you would, but it's just I've never seen a witness come down off the stand to have a meeting with the client and then resume. But I mean, have a meeting with the lawyer, but whatever. I mean,
Mr. Stone, I do understand your point in the context of where we're going right now. I think for us not to be here for 5 hours,
sure,
it's better to have a frank and honest conversation with Mr. Washington.
Sure.
About, if I ask you what day it was, respond to the day.
Understood.
And you'll have the opportunity to converse or cross-examine Mr. Washington.
We're ready to proceed, Your Honor.
Okay.
No.
Hold on. Let me stop real quick, and I'm sorry. Mr. Looper, did you and Mr. Dent reach an agreement?
We did, Your Honor. We did reach, with your assistance, we did reach a payment arrangement that will put in a proposed consent order that needs to be drafted, but we did a confirmation email saying that it'll be a monthly payment towards the full balance per consent order.
Okay, Mr. Looper, do you think you can get that agreement to me within the next 2 days?
Absolutely. Well,
Thank you.
I need their review and their final blessing and signature, but yeah, 2 days should be reasonable. I'll be in communication.
I understand. And Mr. Dent, is that your understanding that you two have reached an agreement?
Yes.
Okay, thank you, sir. You may be excused, Mr. Dent. Mr. Looper, you may be excused. And Ms. Dent, to the extent that she may have come back home.
I'm here.
Okay, you may be excused also.
Thank you for your assistance, Your Honor.
You're welcome. And Mr. Stone, I try to keep the bus moving.
Understood, Your Honor.
That's all. Okay, Ms. Amin, let's continue back up with the examination of Mr. Washington.
Yes, Your Honor, and I apologize for the slight disruption. Mr. Washington, does the invoice, the landmark invoice that you've identified in Exhibit 1, does it list all the labor and services that were to be provided for the $5,800?
No, it do not.
Okay, was it your understanding that the $5,800 was going to fix all of the problems with overheating?
Yes.
Okay, and did you pay the $5,800 to Landmark?
Yes, I did.
Okay, and did you eventually, so did you leave your car with them for repairs?
Yes, I did.
And at some point, did you pick your car back up?
Yes, I did.
And you were able to drive it off of the lot, right?
Correct. Yes.
And did you continue to have problems with overheating?
Yes, I did.
Okay, when did you notice problems with overheating again?
I would say 1 week later.
Okay, and when did you try to contact defendant Landmark to let them know that you were having problems with overheating?
1 week and 1 day, the next day.
Okay, and what was their response when you contacted them?
To bring it, no, I'm sorry. First response was to, that's normal, just continue to drive it.
Okay, and did you continue to drive the car?
Yes, I did.
Did you continue to notice problems with overheating?
Yes, I did.
Did you eventually take your car back to defendant Landmark?
Yes, I did.
And when was that?
That had been around, I want to say July. Let me double check. I'm so sure. Yes, should have been July or August.
Of 2020?
Yes. And the reason why is because when you come around the clock, COVID had kicked in. And I was not moving around from February all the way until that following year. No one was open.
So did you continue to drive your car or did you not drive your car because you were?
No, I did not. Once I got to 10,000 miles, I stopped.
Okay, so eventually when did you bring your car back for repairs to defendant Landmark?
It should have been July or August.
Of 2020. Is that correct?
No, or July, yes, of 2020. That's correct,
Thank you.
2020.
Thank you.
Okay, and at that time, had you had a second diagnostic performed on the vehicle? Did someone else look at the vehicle
Yes, they
before you
did. Yes,
took
they
it back
did.
to defendant
Yes,
Landmark?
they did. Yes,
Okay.
that's correct.
What did you learn from that inspection?
I learned that they did not put a long block in the vehicle.
And did you receive paperwork showing the results of the inspection?
Yes, I did.
And can I refer your attention to exhibit 4?
I don't have an exhibit 4. Are you talking about my exhibit 4? I apologize for speaking
Plaintiff's
directly to counsel.
exhibit 4.
I don't have that. I have an exhibit. Well, actually, excuse me. It's handwritten, says exhibit 4, but it was titled exhibit 5. Palmer Dodge.
Yes.
Okay, apologize for interrupting. Sorry.
No,
And
sir.
I apologize for mislabeling. Mr. Washington, can you identify that document?
Yes, that's a Palmer Dodge in Alpharetta, Georgia.
And does it have the date that you took your car to them?
Yes, it does.
And what date does that show?
That's July 10th, 2020.
And on that document, does it show what they found
Yes, it
after
does.
inspection?
Yes.
And what does it provide?
It says that the long block, that it needs a long block.
Okay, and did anyone explain to you what that meant, what the long block was?
I don't recall. I have to say I don't recall that fully, but yes.
Okay, did you pay for this inspection with Palmer?
Oh, yes, I did.
And how much did you pay?
$166.
Okay, and at that time, did you then take the vehicle back to Landmark?
Yes, I did.
And I think we established that was on or around July 2020.
Correct.
When you took the car back to Landmark, did you tell them what you learned about the car?
Yes, I told them.
And what was their response?
That wasn't true.
And do you remember the person you spoke with at Landmark?
I spoke to Jason Long as well as Brian Gordon.
Did you ever speak to Mr. Stone's witness, Mr. Valdez?
Never spoke to him in my life.
And was it your understanding that the car was still under warranty at the time that you dropped it off in July 2020?
Yes.
And so now I would refer you to Exhibit 2. Did you have Exhibit 2, Mr. Stone?
Yes, I do.
Okay. And can you explain to the court what Exhibit 2 is, Mr. Johnson, and identify the document? Mr. Johnson, okay.
Were you speaking to me?
Well, at this time, Your Honor, I would ask that Exhibit 1 and Exhibit 4 be admitted.
Mr. Stone,
I don't have a problem with 1. Exhibit 4, it's been no authentication. There's no foundation.
Ms. Amin,
Mr. Washington, on Exhibit 4, is this the document you received when you took your car to Palmer Dodge?
Yes, it is.
Is this a true and correct copy of what you received from them?
Yes, it is.
And does this adequately reflect what you believe was being done to your car when it was at Palmer Dodge?
Yes.
And is July 10, 2020 the accurate date that you took your car to Palmer Dodge?
Yes.
I still think it lacks foundation as a business record. There's no one here from Palmer Dodge to authenticate it.
Ms. Amin,
Your Honor, my client did state that that this document was given to him by Palmer Dodge and that it was a true and accurate reflection of what was given to him by Palmer Dodge. So I would ask that as in magistrate court that you allow the exhibit to be admitted.
Ms. Amin, I don't know how I feel about that. Sounds like you're calling me from Little League. I'm joking. I'm gonna admit it over objection. Go ahead.
Thank you, Your Honor. All right, can I refer your attention to Exhibit 2, Mr. Washington?
I have it.
And can you identify that document?
It is a pickup receipt on 8/19/2020
From,
Landmark.
okay, and we established earlier that you dropped your car off on July 24th, right?
That's correct.
And this document, Exhibit 2, says that it has a note pickup 8/19/2020, correct?
Correct.
Now, you don't know who wrote that note on it, right?
No, I don't.
But when you received it from Landmark, was that note on there?
Yes.
Pickup 8/19/2020?
It was.
Okay, and why do you know why it took almost a month for your car to be able to be picked up?
They did not repair the vehicle, and under that contract, which they provided 2-year warranty, I decided to go out and look for an attorney, and that's why it was there. And and long story short, they didn't want to repair the vehicle.
Okay, and did they explain to you why they did not repair the vehicle at that time?
No, I think he said they did not want to repair the vehicle.
Okay, did they explain why they didn't want to repair the vehicle at that time?
Because of the long block that I was indicating to them. And they said that was not the problem.
Okay, did they explain to you why it was not the problem?
And I'm going to say this correctly, they literally refused to talk to me at that point.
Hold on. You can't say that they communicated something to you, but then they refused to talk to you.
Mhm.
It can't be both.
It drop off, they were talking to me. And then by the next day, they just stopped talking to me. And I asked them to look at the engine again. I took it into court to be looked at again.
Did you ever ask to speak to a manager or anyone?
Yes, I did.
And do you remember what manager you asked to speak with?
I don't recall at that time, no.
Okay, did you ask them whether the car was not working because of one of the repairs that they made?
I definitely, yes.
And what response did you receive?
Mm, I don't recall that either.
Okay. Were you ever advised that the long block was part of the overheating problem or not?
Yes, I was.
Okay.
Who advised
And-
you? I'm sorry, Mr. Mean. Who advised you of that, Mr. Washington?
What was the question? Who advised me of
That
what?
the long block was a part of the overheating problem. Who advised you of that?
It's Palmer and
Okay.
Alpha.
Palmer,
Yes.
Jeep, and Alpharetta. Okay,
Correct.
thank you, sir. I'm sorry, Mr. Mean.
No, thank you, Your Honor, for clarifying.
Well,
I would move to admit plaintiff's exhibit 2 into evidence.
no objection to plaintiffs too, but I do object to the hearsay of whatever Palmer may have told him about overheating. It's not in the written record that Your Honor has admitted over objection, and they've not brought a witness from Palmer to testify about that. The Palmer record says nothing about overheating, at least.
I sustain your objection, and just so you know, Mr. Stone, because it's bench trial setting,
Yes, sir.
there's stuff that goes in one ear and out the other.
Sure.
Okay.
Thank you, Your
Go
Honor.
ahead, Mr. Mean.
Okay, when you picked your car up from Landmark, was that which we established was on August the 19th, 2020? Did you notice any exterior damage to the car?
Yes, my windshield was cracked.
And was your windshield cracked when you dropped the car off?
No, it was not.
And during the time that you had the car at Landmark, that was continuously from July 19th, from July until August 19th,
That's correct.
July 24th until August 19th, is that correct?
That's correct.
And this
And
is in the year 2020.
Correct.
Thank you.
okay, and to your knowledge, did anyone else have possession of your car until in between those dates?
No, just Landmark.
Okay, and when did you bring to Landmark's attention that your windshield was cracked?
On the date of pickup on
And
8/19/2020.
were you provided an explanation as to why it was cracked?
No,
And what were you told at that time?
that we're not going to rewind the video footage to see what happened, and that cracks happens all the time. That just doesn't happen like that. I was just told that it happens like that all the time.
So did defendant Landmark ever reimburse you or replace the windshield?
No, they refuse.
Did you ever have the windshield replaced or repaired?
No,
Okay, so it's still in that same condition?
yes, it is.
Okay, and did you reasonably rely on defendant Landmark to repair the overheating problems with your car?
Yes, I did.
And based on their representation that they would fix the car, did you pay them $5,800 to fix the car?
Yes, I did.
And do you believe that the car was fixed according to what your expectation was?
No,
And but do you believe that you sustained damages and loss based on the representation that defendant Landmark was going to properly fix your car?
Yes,
And based on how your car drove after you took it from the dealership back in June 2019, do you believe that the workmanship was performed to a proper standard?
no, it was not.
And is that based on your car's performance while you were driving it?
Correct, yes.
And can you tell us what you noticed or any issues that you noticed relating to overheating after the car was supposedly fixed?
The entire engine was shake by the time I get to 55 miles an hour.
And did it continuously do that?
Yes, it did.
And when you notified them of that a week later, your testimony, I believe, was that they told you to continue driving it.
Correct, yes, they did.
Okay, but you also said that because of COVID, you didn't drive the car much either, right?
Yes, that's correct.
Okay, did you incur any damages based on your reliance with Landmark Jeep that the car was properly fixed?
I'm sorry, you broke up a little bit. Can you repeat
Did you
that?
incur any other damages besides the $5,800 that you paid Landmark regarding the car?
I don't know if you factor in like the car rental. I don't know if you factor in that I had to store my vehicle. Those are just financial damages, but outside of that, no.
So because because you testified that the car didn't run right, did you end up having to rent a car from someone else?
Yes, I had to rent a car for 2 months, and then I had to turn around and buy a used car because they never fixed my car right, and I had to get back and forth to work. And then in reference to storing the vehicle, I had to pay for that.
Okay, and where did you rent cars from?
The Atlanta airport.
Okay, was it from the same rental car company?
It was mixed in. Some of them were pay less. I did that for about a month, and then there was like Advantage. So there were like different car companies.
And how much total did you spend on rental cars?
Oh my God, easily $2,800 to $3,000.
Okay. And did you use a charge card for
I was using
paying for the
charge
rental
cards,
cars?
credit cards, every special they had. I was using everything.
Okay. And did you eventually have to store the car?
Yes, I did.
And where did you store the car?
The first place I stored it, it was down. Let me get to it's right down the street from Landmark because I didn't want to drive it. I can't think of the name of it right now, but it was a public store. It was a public storage. That's what it was. It was a storage place, but it wasn't public. It was in storage.
Okay, and do you remember the name of the
Miss
storage?
Amin, can your client explain why he had to store the car?
The reason why I stored the vehicle because I did not want to put 1 mile on that vehicle because I knew that I was going to get to this point and I refused to drive it. So I had it stored in the storage.
Couldn't you have towed the car?
It was only a mile down the street. It's probably, yes, exactly 1 mile down the street.
How much was the storage?
$200 a month, and I did it for 6 months.
Wouldn't it have been less than $100 to tow the car back to your home?
I cannot have 2 vehicles where I live at. I live in a loft, and I have a 1-bedroom loft, and they will not allow me to have 2 vehicles. And
Okay.
being that they caused me to have to go buy another car, I had to store my truck.
Okay, go ahead, Miss Amin, I'm sorry.
All right, so you said you paid about $200 a month for 6 months?
For 6 months.
Okay,
And then I took it out and I had it towed to a friend's house because it was cheaper to get it done for $100 a month.
and what was that friend's name?
Shakita Lampkin.
And how long did you have you paid her for truck storage?
A year and at least 4 months.
And how much do you pay per month for that?
$100.
And did you pay how did you pay Shakita?
I pay her with Cash App.
And when you make a payment to someone through Cash App, does the receipt come directly to your phone?
Yes, it does.
And can I refer you to Plaintiff's Exhibit 7?
I think I have a 7.
All
Yes,
right,
sir.
can you identify that document?
Did you say you do not have it or you?
I do not have a 7.
Okay.
Hold on, Your Honor.
Apologies.
I
Let
will
me
send
just
him
double
that
check.
directly.
Yeah, I don't have a 7. I have an email with 8, 9, another email with 10 through 12, and then 1 through 5. Excuse me, 1 through
And 7 is
6.
7 the receipts showing for payment to this friend that was charging him $100 a month?
Yes, Your Honor.
Okay,
And I'm sending that to Mr. Stone. Give me one moment, please.
okay. And while you're
Thank
doing
you for
that,
your
I
patience.
do have a question for Mr. Washington.
Yes, Your Honor.
If it's appropriate, right
It's
now.
appropriate. You can ask. You have my permission.
Thank you, man. Mr. Washington, you indicated early on in the examination that the receipt from Landmark Dodge does not reflect everything that you expected to be done to the vehicle. And I just want to try to clear that up and just understand if that was your intent to say that I got an invoice, it told me they're going to do X, Y, and Z, but it left off ABC. Is that your testimony, or was it because I couldn't tell? It seemed as though you were saying that you were not satisfied.
I was not. It's just.
Hold on. Let me
Oh, I'm
finish.
sorry.
That it seems as though you were not satisfied, which I understand, and that's why we're here. But if your response was meant to say that you were not satisfied, I understand that. But if your response is that you got an invoice and there were things that were supposed to be done to the vehicle that were not on the invoice, that's a separate thing. So I want to give you the opportunity to clear that up. Do you understand my question, sir?
Yes, I understand your question,
Okay.
but it's almost like a two-sided thing. And if I can just state this, I believe they overpromised and underdelivered on that actual contract.
So let's stop right there. Your belief that they overpromised and underdelivered is a separate issue from whether they gave you an invoice that says this is what we're going to do.
Mhm.
But there were other things that you expected to be done that were not on the invoice. And by not on the invoice, meaning you were not expected to pay for that.
I know what you're saying now. I was
Okay.
expecting everything that was on that piece of paper. Yes.
And
Which
may I ask a
essentially-
follow-up question, Your Honor?
Yes, ma'am.
On the invoice labeled Exhibit 1, I think we discussed this earlier, but there is no itemization of what all the $5,800 was going to cover, what repairs it would cover. There's no itemization on that invoice. Is that correct?
That's correct. That's what I'm reading, but I gotta compartmentalize things. And so just so you know, Mr. Washington, as I'm putting things together, it's 1 + 1 = 2. It's not A + B = C². It's I gotta boil it down so that I understand where I'm coming from, because ultimately I'm going to have to make a ruling in this case, and I need to understand the evidence. Okay, go ahead, Ms. Mean.
Okay, Mr. Washington, just to clarify, when you paid Defendant Landmark $5,800 to repair the overheating for your car, was it your belief that you were paying for them to fix everything involving the overheating problem?
Yes,
And in the invoice that you received from Landmark marked as Exhibit 1, they did not list exactly what they were going to repair or not repair. Is that
Correct.
correct?
yes,
But did you assume that that meant they were going to fix everything
yes,
that was causing the overheating?
yes,
Was it also your assumption that you had or was you also under the belief that you had a 2-year warranty on all the repairs?
correct.
And did you believe that Landmark would act in good faith and make any repairs if anything was wrong with the car within the warranty period?
Correct.
And did Landmark in fact correct or make any repairs to fix any of the continuing overheating problems that you experienced?
No, they did not.
Okay. Now, may I call your attention back to, did you receive Exhibit 7, Mr. Stone?
Sorry. Yes, thank you.
Okay, and can you identify Exhibit 7, Mr. Washington?
That's the monthly statements that I was paying my friend Shakita to store my truck.
And did these were these receipts sent and generated directly from your phone?
Yes, it was.
So you actually have these receipts in your cell phone right now?
Yes, I do.
And does Exhibit 7 match what's in your cell phone from?
It should be about a good 14 months. Yes, it does. It match.
Okay, and what application did you use to pay Shakita?
It was Cash App.
And did Cash App send you these notifications of payment and,
Yes.
and the history showing the payments?
Yes, it did.
And what is the approximate amount of the payments?
Should be about 1,600.
And is that what you have paid so far for storing your car at Shakita's home?
Yes,
And if you were allowed to keep more than one car at your current residence, would you just park your car, the 2012 Grand Cherokee, at your residence?
if I had one, yes, it would be at my residence. Yes.
Okay. And what would the consequence be for you having more than one car at your residence?
They won't allow it. They just gonna have to tell me that the car has to go. You only allow one vehicle for one bedroom. So
Okay,
I would actually have to give up one vehicle.
okay. And after paying defendant Landmark $5,800 to repair your car, what would you have expected them to do when you brought your car back with the continuing problems?
To find out what it is, what the problem is, but inspect and find out what was the problem for it being the problem. Well, expect to find out why is it having a problem.
And do you believe that Landmark Jeep honored the warranty that you were promised?
No, they did not.
Okay. At this time, I have no further questions, subject to redirect, Your Honor.
Okay, before you get started, Mr. Stone, I have some questions for Mr. Washington.
Sure.
And it's based upon the exhibits that have been submitted. Looking at Exhibit 1, it says that the invoice date is June 13th of 2019. And the mileage listed is 162,153 miles. When the vehicle is taken to Palmer in July of 2020, the mileage is $172,298. I mean, dollars. 172,298 miles.
That's correct.
And the invoice from, I think, Landmark, which I think it is Exhibit 2, that has an invoice date of August 3rd of 2020. There's a mileage of 172,367 miles. Having the benefit of being a college student and being a poor student in law school, I've had crappy cars. It looks like you drove that car more than 20,000 miles in a state where you're saying, I'm sorry, 10,000 miles in a state that you said the car wasn't no good. And then when I say having crappy cars, it mean like turning on the heater to help cool the engine down when there's an overheating issue with the car. So cars driven 10,000 miles, Mr. Washington. If I take your testimony as I heard it, the car is in an inoperable state. Could you explain that to me, sir?
I sure can. I told you once I get to about 55 miles per hour, that vehicle, you can feel the shake on it. I could not ride it on the freeway at, if say the speed limit 70, I had to stay at 55. That was the only way for me to travel. I had to stay at 55 miles per hour. And I indicated that further back. And in reference to it overheating, there was times that I literally had to just, once you get to a certain speed, it's over. And this is what I was trying to explain to them. I was like, I don't understand what is going on with my vehicle. I wish I could, but I'm not a mechanic.
Now, Mr. Washington, you have to explain what you mean when you say it was over, because I don't understand what that means.
You say, I'm sorry, Mr.
You said when I got to 55, it was over.
Yeah, if I go over the engine.
Sir, explain to me in words that I can understand. Speak to me as if I'm a 7-year-old when you're explaining what is going on with this vehicle.
Driving my vehicle, anything under 55 miles per hour, you can't feel a shake in that vehicle. Once you get to 55 miles per hour and the speed limit is 70, that whole entire engine will, the shake will, you start to feel it increasing. So I had to stay at 55.
Okay, so what you just described to me could be motor mounts, could be wheel bearings, could be transmission, could be something that is loose. We're here about an engine that was supposed to be repaired. That, hold on, sir, listen to me before you respond to me. Because all I'm asking about is what you're claiming was wrong with the vehicle. And believe it or not, Mr. Washington, I got this black dress on for a reason. It's because I make a determination. And so you can fight with me, or we can have a discussion about what I am trying to get an understanding about. That's all these questions are about. Just trying to get an understanding. Okay, sir? So what makes it to where you believe that it was the engine and the repairs that were done by the defendant that caused this matter?
Before my car overheated the first time, no shake, no nothing, beautiful truck, $80,000 truck. After I took it to Landmark, the very next day, I realized, was that a shake? Kept driving. By the time I got to the end of the week, that is a shake. They did not fix my vehicle properly. Never had a problem with my vehicle, ever.
Okay.
So that's why I feel that they didn't do something right, because I've never had that problem before until it came back from them.
Okay, Ms. Amin, do you have any follow-up questions based upon what I asked?
Yes, Your Honor. Well, as the judge stated, you put about 10,000 miles on the car and you took it back to Landmark Jeep stating that you thought the car was overheating. Did the car give you any indications that it was still overheating while you were driving it, or was it just the shake only?
It was both.
What indications did the car give you that it was overheating?
Once you get over 50, once you at 55, 60 miles per hour, after about 35 minutes to, I say somewhere about an hour, it starts. But then when I stay, which I'm not a mechanic, if I'm riding in the city, I'm okay. But it's just something that they did not do, that once I get over 55, that's when the problem kicks in.
Okay, let me ask you again, okay? What indication did you have that the car was overheating, not shaking, overheating?
The C to the hot, the meter, it will start to approach the H.
So when the car was shaking, was the meter also going from C to H, I assume?
Not all the time, but some of the times, yes. It's a fluctuation of crazy problems with that vehicle since they repaired it.
Okay, did you ever, when the car, I guess, gauge went into the hot mode, did you ever get out of the car and look under the hood?
I actually, yes, I pulled over a few times.
And could you visually tell any indications that the car was actually overheating?
That fan is blowing and the engine is just screaming hot. That fan is blowing so hard that it's just like, let me let this thing just cool off.
And when the car shook, some of the times the gauge would also go from cold to hot,
Yes,
indicating that the engine was also turning hot.
that's correct.
And is that why you associated the shaking with the overheating?
Yes.
That's all, Your Honor.
Okay, and I'm gonna let you start, Mr. Stone, but Mr. Washington, again, I've had experience with cars that would overheat, and shaking was never something that I've ever understood to be associated with a overheated or an engine that's overheating. Yes, sir, Mr. Washington.
In the beginning, I don't know the gentleman that's speaking with the headphones on. I don't know his name.
Mr. Stone.
Yes, he indicated that the vehicle, when it was brought back, that it was to be repaired. When I brought the vehicle back, and please hear me, they never ever said we will repair it. They told me, you need a new engine. You done paid us $5,800. We're not going to repair it. You need a new engine. Where'd that come from? And that's not what he stated. He stated something totally different. They never stated that they was going to repair them up under my 2-year warranty.
Well, and I'm certain that that'll be an issue that is addressed. And I don't know, Mr. Stone, if this is a situation where I know at some point there were a number of engines in the Jeep Dodge family that were being recalled because of issues. And I don't know if this car fell into that or it didn't fall into that. But I'm going to now turn over cross-examination to Mr. Stone.
1 second, Your Honor. I just want to make a note. So when I ask, okay, I'm going to ask about the recall when my witness comes up. Mr. Washington, you're not an automotive mechanic, are you?
No.
You have no training as an automotive mechanic?
No.
You have no experience as an automotive mechanic?
No.
That's why you brought your vehicle to people who have that experience, correct?
Mr. Washington, I have a 1:30 calendar, sir. Please just answer the questions.
Repeat the question again, please.
That's why you brought your vehicle to people who do have experience and are trained mechanics.
Correct. Yes.
Right. You purchased your vehicle new in 2012, is that right?
Correct.
And have you been the only driver of the vehicle?
Yes, I have.
And so you put when you brought the vehicle in or had the vehicle towed in to Landmark Dodge, that was on May 31st of 2019, correct?
I don't recall that.
All right. You have my exhibit 3, correct? These were exhibits I provided to your attorney. If not, I can put it up on the screen.
It's June 3rd, 2019.
Well, Your Honor, may I share my screen?
Yes, sir. You should be able to share your screen.
All right, Mr. Washington, can you see this document, which is Defendant's Exhibit 3?
Yes, I do see the screen.
Is that your handwriting?
That is my handwriting. Yes,
Is that your signature on the bottom?
That is, but I have a question for you.
Well,
Hold on,
I'm
wait.
I'm the one asking the questions. This is May 31st, 2019. You wrote that date at the bottom?
Correct. Yes.
Okay. And so you brought your vehicle, you had it towed in to Landmark, and your complaint of the problem was that it was overheating, and you said, you guessed it had something to do with the water pump. I can't read the rest of it, but anyway, this is all you're writing from when you had the vehicle towed in, correct?
No.
Sorry.
No.
I'm sorry.
No, that's not
Okay.
correct. I know what that is. I know exactly what that is.
Okay, what is this?
That's when I filed to get you guys served. That is not anything that has to do with your trade, with your logo or anything. That's when I had to take you guys to, because if you look at it, that's not it.
Well,
that's not yours.
Mr. Washington, to the best of your ability, would you please finish a thought?
That's not Landmark's paperwork, Your Honor.
Okay.
Well,
go ahead, Mr. Stone.
I'll have Mr. Valadez authenticate it, but if you see here, it says at the top, instructions: fill out all the parts of this form completely, park the vehicle on our lot and lock it, tear off and claim and check, tear off, claim check above and keep, place the keys in this envelope and seal, drop the envelope in the early bird owl slot, or excuse me, the bird night owl slot. This is clearly not anything to do with filing this lawsuit. It has to do with when you dropped off the vehicle.
That was late at night. Now I know what that is, but yes.
Well, now you know what it is the second time.
Now I know what it is. That's when it happened late at night. Yes,
right.
That's when my car first overheated. Go ahead.
I understand. So that you filled out this form and dropped off your vehicle at Landmark Dodge on May 31st, 2019.
That's correct. Go ahead.
I'm going to show you now what's been marked as Defendant's Exhibit 4. This is the same as your Exhibit 1, I believe. This is the repair order that was opened on June 1st of 2019. And this contains the complaints, or what's called the story. Customer states the vehicle is running hot and fan does not work all the time. You see that?
That's correct.
Okay. This is the document. This is the second page. This is a document that we were looking at before, except it has more information than what was on yours. This is yours. I just flipped to. You'll see this. You see the dates here. June 1 is when the repair order was opened. RO date, repair order date, and invoice date. That would have been the date that the vehicle was, or the invoice was paid. Now I'm going to go back to Defendant's Exhibit 4, which is a more comprehensive or more complete copy of it. This again has the story here. Customer states vehicle is running hot and fan does not work. It contains a description here of all of the things that were done to diagnose the problem. And down below here, it contains a list of all of the parts that were replaced. And on the next page shows that you paid $5,800 on June 13, 2019. Is that right?
That's correct.
Okay. And I don't know if you're able to read it, but this highlighted piece right there, I want you to focus on that, and I'll make it bigger. Well, maybe I made it too big. I apologize. Can you read right here where it says, "We guarantee"? Can you read that?
Yes,
It says we guarantee our service labor for 12 months or 12,000 miles, whichever comes first. If our repair or replacement falls in the normal service within that period, we'll fix it free of labor charges. Did I read that correctly?
You sure did. Yes,
Okay.
You did. Can I ask where's the back page to that? Because there's a Jason Long who put, "We guaranteeing you a 2-year warranty." I remember Jason writing a 2-year warranty on one of those pieces of paper.
And where is that? Because I have never seen that. You're saying Jason Long made these statements to you, and now you're saying he
No,
wrote
he
it down.
wrote it on a piece of paper, so I don't know if it's on that one.
Where is that piece of paper? Show me that piece of paper.
Oh, well, you know what? You even stated, the gentleman who owns the dealership.
Mr. Washington, let's start with first answering the question.
No, it's not on there.
Okay.
It's not on that piece of paper.
I understand it's not on the piece of paper that I have on the screen, which is Defendants Exhibit 4. My question to you is, where is that piece of paper that you have that you say Mr. Long gave to you? Because I've never seen it. That would be an important piece of evidence for you to have.
Mr. Long wrote 2-year warranty on it in that same section.
My question to you, sir, is where is that piece of paper with Mr. Long's handwriting on it? Because I have never seen it. If you have it, I would like to see it. That's an important piece of evidence.
1 second, please. I can't. Your screen. You continue to ask me the questions while I'm looking for it.
Hold on. Mr. Washington.
Yes.
I would presume if you had this information, you would have given it to your lawyer, so your lawyer can do the best that she can to defend you. So if you have it, you have it. If you don't, you don't. And either one is fine.
Okay. Well, with that being said, Your Honor, can we go back to the YouTube that we were live, if it was live, where he even said it himself? It's documented. He even said a 2-year warranty.
Nothing I say is evidence.
No, the guy who owns the dealership, he even said it.
Okay.
He said it. Wow, the very first time we met.
Mr. Washington. And I'm not prejudging anything. I'm just trying to explain it to you so you can help us all get to where we need to go.
Can we continue?
Okay. So you bought the car in 2012. Here we are in June of 19. So that's 7 years. You put 162,000 miles. That's about 23,000 miles a year on the vehicle before you experienced this overheating problem, for which you brought it to Landmark Dodge. Is that right?
Correct.
Okay. We'll go to what's marked as your exhibit. I guess this is exhibit 4, which is from Palmer Dodge. I'd like for you to tell me, this is what happened next, is in June of 2020, you took it to Palmer Dodge because you were experiencing problems. And it states here in the story here, customer states that engine has a knocking noise. Customer has had cylinder head replaced by Landmark Dodge. Please check and advise. Customer declines work at this time. Needs a long block parts and labor, $9,380. Did I read that correctly?
You read it correctly.
Where on here does it say that that you were experiencing or complaining about an overheating problem?
It does not state on there.
Okay. Next thing that happens is you took it back to Landmark Dodge, and I'll use my exhibit. I believe this is 5, which is the same as your exhibit, at least the first page is. It says here under the story or the complaint, customer states there's a knocking noise when pressing the gas. Check and advise. Okay, did I read that correctly?
Yes, you did.
It's essentially the same thing you told Palmer Dodge, right?
Yes, it is.
And where on here does it say that you were complaining of overheating?
I did not.
It says here that they verified the customer's concern about the knocking noise from the bottom of the engine, scanned for codes, found codes for MDS solenoid failure cylinder number 4, which indicates metal in the oil passages, has internal bottom engine failure, needs engine, estimate 11,300 plus tax, but did tell customer will get down to $9,047 plus tax and engine, carries 3-year, 100,000 mile warranty at any Jeep dealer nationwide. Did I read that correctly?
You sure did.
Okay, and you declined to have the bottom end of your engine repaired by Landmark Dodge. Is that right?
Yes, it is.
Okay. And the next thing you did was to file this lawsuit in September of 2020. Is that right?
That's about right.
Okay. Landmark never told you it was going to make any repairs to the bottom end of your engine, did it?
I don't recall that.
Meaning that never happened, or you don't recall it?
You're going from the top to the bottom. I don't. It's just engine.
Wait.
Okay. So I'm gonna take that answer as you don't recall ever being told that. Okay.
Okay.
When you brought your vehicle to Landmark in June of 2019, Landmark diagnosed the problem as the top end of your engine. You authorized repairs. They made those repairs, correct?
No. You did not repair my car, but only one time.
You brought your vehicle to Landmark in June of 19, correct?
Yes.
They made repairs to your vehicle, correct?
No. They never made repairs. You only fixed it once. How you gonna say repair?
So, Mr. Stone, I'm accepting that answer as he's not satisfied with.
Okay, that's fair enough. All right. The fact is, you have no evidence whatsoever to dispute that the top end of your engine was properly repaired by Landmark Dodge, and a completely separate issue relating to the bottom end of your engine was what manifested 10,000 miles later when you took it to Palmer Dodge, and then a few days later to Landmark Dodge. True?
That's not true either, because Palmer never even stated anything about a bottom. Only you are. They said it's a long block.
Long block is the bottom, Mr. Washington.
And that's what they did not perform. That's what they did not do correctly.
But you paid for, you agreed to pay for and received repairs to the top end of your engine from Landmark Dodge in June of 2019.
I sure did. Yes,
that's right. It has nothing to do with the bottom end or the long block problems that manifested later.
I'm not a mechanic.
That's right. You're not a mechanic.
Said that you didn't do it right. That's what you didn't do.
Let's look at the Palmer Dodge. Having trouble finding it here.
You just went past it.
Is this it? Oh, thank you. It says customer states that the engine has a knocking noise. Customer has had cylinder head replaced by Landmark Dodge. Please check and advise. Customer declines work, needs a long block, parts and labor. Nowhere in there does it say that Landmark failed to do what you paid for, which was to repair the top end. Nowhere in here does it say that Landmark did anything to affect the long block or bottom end of the engine. True?
That's not true.
That's not true. Point to me where it says that.
Needs a long block part.
What if it said it needs a new left tire? Would that be Landmark's fault?
In order for me to drive it, yes, it would be. Yes, it would.
Okay.
Because that's what's needed to drive it. And you did not put in the long block. And that's the part that needs to go on for the job that you did.
Okay. I don't have anything further for this witness.
The engine was shaking the very next day.
Miss Amin, do you have any redirect?
Yes, I do have redirect. When you first took the car to Defendant Landmark, you took it in for overheating. Is that correct, Mr.
That's it.
Washington?
Yes.
And did you did you have any idea that the car had other problems with the engine at that time?
No other problems.
And did Landmark Jeep ever advise you that the car might be subject to a recall?
No, they did not.
And knowing what you know now, do you think that what you thought was overheating might have actually been an engine problem that
I'm gonna,
you weren't
sorry.
told about?
I'm gonna
No,
object
I'm-
first.
Just overheating.
I'm a overrule it, but the answer is I think immaterial.
When he has no experience by his own admission.
I understand. I do. Because there's a, go ahead. I'm sorry. Because I really gotta not talk and let the litigants move forward. Go ahead, Miss Me.
So knowing what you know now, do you believe that you had an engine problem and not an overheating problem?
I only had a overheating problem when I took it to them. The engine occurred after they fixed it.
Okay,
After
and-
they proceed to go beyond just fixing the regular heating issue.
but you were never advised of any recalls or issues
No,
with the car, as
No,
far as recalls?
no, it was in perfect 100% shape.
Okay, that's all the questions I have.
Mr. Washington, I don't know how you can say a car with 160 something miles on it is in perfect 100% shape. Do you have any other witnesses, Mr. Me?
I do not, Your Honor.
Okay. I'm gonna stop this. I'm gonna find that plaintiff has not met their burden of proof and production. There are problems that happen with cars all the time. Overheating is not related to some of the other issues that you have brought up. And there clearly there was you're not happy with what took place. But it doesn't necessarily mean that it was Landmark's fault. So this case is going to be dismissed.
Thank you very much, Your Honor.
I'm not guilty. Okay, the parties in this case may be excused.
Thank you.
Thank you, Your Honor.
Thank you.
But who's gonna do the dismissal, you or?
I'm gonna do it.
Okay.
Well, Mr. Stone, since
Yes.
you're the lucky winner, you get to send me in a dismissal for my signature. Thank you, Miss Mary.
I'll be happy to do that.
Okay.
Thank
Mr.
you.
Stone, send it to me so that I can make sure it gets signed and processed.
Okay, I believe
and-
your address is in the chat.
Yes, it is.
Okay.
You want me to send it to you again?
No, no, ma'am, I have it right here. Mary.Moultrie@ClaytonCountyGA.gov.
That's correct.
Okay, I'm just writing it down.
And Ms. Washington, I think your lawyer did a great job. I don't think you did anything to help yourself along this way. And I understand how you feel about what you believe Landmark Dodge did or did not do. But these cases are ones where you're placed in a very difficult situation and trying to prove where you are. So Mr. Valadez, sir, you can be removed. You can leave. Mr. Washington, you can leave. Ms. Amin, you can leave. And Mr. Stone, you can leave.
Thank you, Judge.
Thank you, Your
You're
Honor.
welcome. You're welcome. Do we still have Holmes Customs here?
Your Honor,
Yes.
I'm sorry.
Go
Your
ahead, Ms. Gregory.
I just wanted to remind you that Parr's Cars was still here with Austin.
Okay,
Thank you, Your Honor.
let's do that. Holmes Custom, it was the plaintiff was present earlier, but the defendant wasn't present, and I was just gonna try to move that quickly. All right, so we're dealing with position 5, Candrace Austin versus Parr's Cars. And my understanding is Parr's Cars, we have John Ash as a witness and Miss Austin, you have 3 persons that are witnesses. Is that correct? You're still muted, ma'am.
I'm sorry, guys. Yes, I have 3.
And let me check.
One witness you put in a back room, but the other 2 witnesses have been on with us the entire time.
Okay, and
Your Honor, the defendant is in the back room
okay.
or a breakout room. Sorry.
Let's see.
This is John, also present.
Yeah, yes, sir. We'll be with you in 1 second. So I'm showing participants. There's a says iPhone.
Yes, that's my wife, Robin Austin.
Robin Austin.
Okay. So Miss Austin, you have, I think I've written down a Lowe. Is someone with the last name Lowe is a witness for you?
No.
Okay. Tell me the
Are
name.
you asking about me, Judge?
Alexia Lowe. Yes, ma'am. I had a Lowe as a witness, but I know you're in position 1. Let's see. Who are your witnesses, Miss Austin?
Tierra Morris, the one that says iPhone, and it was the real princess, but she was put into a break room.
And she's no longer showing as being in the break room.
Let me see.
I'm here.
Oh, you're a Zoom user.
Zoom user. Okay.
And tell me your name, ma'am, not your I say not your club name, but tell me your government name.
It's Mariah Harris.
Hill, last name Hill?
Harris.
Harris.
Yes, sir.
Okay. I'm gonna rename you as Miss Harris. And I see we have a Mr. Dennis. Who is Mr. Dennis? Is he a party in this case? Andre Dennis, are you a party in this case, or can you explain what case you're associated with?
Good afternoon. Sorry to interrupt. This is a legally. I do work for the law firm. I represent Kendall therapist and Gabriel Farrell.
Hello, Andre Dennis. I see it's a conference room. There's people talking. Are you associated with the case on this morning's calendar?
Yes, Your Honor. Can you hear me?
I heard yes, Your Honor, but I didn't hear anything after that.
I'm sorry. But yes, we are representing Kendall and Gabriel.
Did anybody hear that? I did not hear that, man. Sounds like you're way away. Can you get closer to the microphone? Ma'am, I just need to identify you, that's all. Okay, ma'am, can you speak now? It may be easier to hear.
Can you hear me, Your Honor? I'm putting it in the chat.
Jesus. I did not hear anything she said. Did anybody hear what she said?
Yes, sir. She said she was putting it in the chat.
All I need to know is that if you're a part of this case or not, and you can work on the sound as long as you want to.
Your
I
Honor,
need to-
this is Eric Gregory for the defendant. I can confirm that Andre Dennis is not here for the defendant, and maybe we can just confirm that with Miss Austin. She's not with Miss Austin.
Not at all.
Okay, let's.
Thank you.
let's keep this bus moving.
Yes, sir. Yes, Your Honor.
All right, let's see. Where are we? Okay, we're live streaming. For the record, this is position number 5, Candace Austin versus Pars Cars. Miss Austin is present representing herself. Pars is present being represented by Mr. Gregory.
Yes,
Mr.
Your Honor.
Gregory, is Mr. Ash a corporate executive?
Yes, Your Honor. He's the manager of the defendant.
Okay, and would you like for him to remain in the courtroom?
Yes, Your Honor.
Okay, Miss Austin, I need you to raise your right hand for me, please, ma'am. You swear affirm the statement you give during this matter shall be the truth, the whole truth, so help you God?
Yes, sir.
Okay, ma'am. Do you need to call your witnesses first, or?
It's totally up to you.
Well, ma'am, I just call the balls and strikes.
Maybe I can give an opening, and then on those parts that where I do start touching, then maybe they can come in and say their part, or
and
they can.
And I'll do this, ma'am, just as a. And I'm gonna put Miss Morris and Miss Harris.
Your Honor, I think we're having an issue with your microphone.
With my microphone?
Yes, Your Honor, I can't hear you. I can see your lips moving.
Okay.
And there was a lot of feedback before.
I'm getting feedback too, and I don't know where that's coming from right now. Can you hear me better, Mr. Gregory? I'm sorry. I said, can you hear me better, Mr. Gregory?
Yes, Your Honor.
Okay. And honestly, sometimes when people are using the earbuds, it doesn't do well on this. So
I'm going to give up on them.
But there, I'm always say we're building a plane while we're flying it. I've placed Miss Morris and Miss Harris in the waiting room. And did you say that Miss Austin is in the iPhone?
Yes.
Okay. I'm going to rename you, ma'am, as Miss Austin. And then I'm going to place you in the waiting room.
Okay.
Okay, Miss, so the reason I did that is that I want to ask you to give what is called a proffer of what you think those witnesses are going to testify to, because sometimes the witnesses are just may just come in to say, yeah, that person's right, and that's not really adding to the evidence testimony. So what do you expect Ms. Austin to testify to?
I'm sorry, I didn't hear the last part. What did I expect?
And the proffer is not that you're testifying, but for me to hear essentially why you're calling, like, what do you expect Ms. Austin is going to testify to? And the purpose of that is me make the determination as to whether we even need to deal with Ms. Austin as a witness.
So she's a main witness because she's been through the entire walk with me. The day I purchased the car, the day the car was towed, the day the car was given, the day I filed. She's actually walked this full walk with me. from the date of me actually obtaining the vehicle.
Okay, so is it fair to say that she's observed everything that you've observed?
Yes, it is. Absolutely.
So that would be my example of the, yeah, she's right witness.
Gotcha.
Accept that testimony from you. I don't need 10 people to say everybody that what they testified to is right.
Right.
Okay?
Yes, so she hasn't had any encounter without me, if that makes sense.
No, it does, but it becomes like a repetitive kind of thing.
Absolutely.
Ms. Morris, what do you expect Ms. Morris to testify to?
Ms. Morris was the person who picked me up to take me to the financing company, and she also was witness to the phone conversations. She was also a witness to the day that I picked the vehicle back up at the financing company. She took me both ways.
So it sounds like you can testify to everything she's going to testify to.
That's true. My purpose of having witnesses is basically that second in that conversation. As you heard the same thing I heard, you were there at the time that I was there. So my wording and her wording could definitely be the same because we were there together in both situations.
And so, ma'am, if I disbelieve your testimony, I'm going to disbelieve her testimony. If I believe her testimony, I don't need the other person's testimony. Does that make sense to you?
It does make sense to me. It makes sense as far as explaining the same, but the point of views could be totally different.
And I'm going through this exercise just so we maybe can not waste time. But ultimately, you have every right to put your case on. And so if you get to the point where you really believe that you need to call a person as a witness, I will allow that. But I just want to go through this so that we're not spending time here listening to the same thing.
Being repeated, absolutely.
Yes, ma'am. Ms. Harris, what do you believe Ms. Harris is going to testify to?
She's the same thing. She was there when it happened in that moment. The only difference with Ms. Harris is that she had to deal with a lot of backlash from the towing of the vehicle. I'm seeing that it was done publicly. It caused her problems in school, caused her problems on the bus. So I wanted her here to explain her anxiety and or her feel of how this made our family feel when Par's cars had the vehicle towed from my home.
Give me a second. What I'm going to try to do is turn the volume down because I am hearing feedback. And maybe that will stop the feedback.
Your Honor, I wonder if we could ask the people that are not part of the case to mute their microphone. There's a few people that come up, it seems like when you speak, their picture comes up. So I'm wondering if their microphone is picking you up.
And it could be. I just muted Mr. Holmes and Mr. Ash. Is that better from an audio standpoint?
No, sorry.
No. I don't know where this feedback is coming from.
Either.
Miss Austin, would you turn the volume down on your laptop?
Is that better?
Testing 1, 2, 3.
Yes.
Is that better?
Is that better?
Much better. Thank you.
Okay.
There we go. See?
I'll do it one better.
You have to learn how to do computers.
Yes. Excellent.
Yes. All right. So, and Ms. Austin, yes, ma'am.
Before you get started on your case, make an announcement to the 1:30 calendar that we are still working on the 8:30.
Okay. So it looks like we have the Dennis Law Firm. We have looks like Miss Castillo, which is position 2. that's coming on. So we're hopefully gonna finish this calendar soon. I saw Miss McLaughlin, and I think she logged out. She was on position 7. And we'll have to deal with that, Miss Mary, because they have Andre Dennis is representing both the plaintiff and the defendant. So we have one more case after this to get to, and then we're going to roll over into the 1:30 calendar. Miss Austin, I think I announced the case. If I did not, this is position number 5, Candace Austin versus Pars Cars. All parties are present here in court. Miss Austin, as the plaintiff, you have the burden of proof and persuasion. So I'm going to allow you to put your case on.
Okay. Okay, can you guys hear me better? I put my headset in so you can't hear any back noises. Great. Okay, so again, my name's Candace Austin. I purchased the vehicle 2011 Chrysler 300 from Pars Cars on actually March the 2nd. On March the 3rd, on my way to work, the vehicle check engine light came on. Prior to that, the power steering went out. I could only make right turns. I immediately text this manager on the property by the name of Tony. He told me to just converse with him. He would assist me. I had the night before, I was there from maybe 10 a.m. to about almost 8, 9 that night. So I'd gotten a little restful. So he told me if anything, if I needed to speak with anybody, then to give him a call. I until text him. And I told him that on March the 3rd, that my vehicle's power steering was out, as well as the check engine light had come on. And he assured me that the service center would check the engine light the prior day, as well as the power steering. And that's in Exhibit A. Mr. Tony also told me in written form by text message that he promised that he would do right by me. So I explained to him upon arriving there on the 4th that the way that my job works is if I take 1 day, I get 1 point. If I take 2 days, I get 2 points, so on. So this particular was Wednesday, and I would be vehicleless all the way through Friday, which I also explained to them that my daughter goes to a summer summit for the University of Georgia through her school. She's an ambassador. So I needed my vehicle to be working for me to get her to that summit. So he told me that they ordered the part, and the part would be in that Thursday. On that Thursday, I gave him a call. I asked him, what's the part there? He said, not yet. So he said, just come on, it's in transit. So I came there from approximately 2 p.m. to almost 4 p.m. I sat there with no recollection of knowing where the part was, if it had come, or any of that. At 4 p.m., the service center gentleman came out and said, hey, yes, we did receive your part. Unfortunately, it's a 4-hour job. I cannot complete it today. So I immediately went to Mr. Tony and I said, hey, this is not what we discussed. I don't have a way of getting my daughter to where she needs to be. It got my voice escalated a little loud. Mr. Tony's voice escalated a loud, which caused a gentleman. I have no recollection of his name. I had never met this gentleman. He until called Clayton County Police. I until called Clayton County Police. When Clayton County got there, I discussed my portion with one officer, and the gentleman who said that he was the owner, he spoke with another officer asking him to step on the inside. I don't have any recollection of what the conversation was, but about 6 minutes later, they came out, and the officer told me that the gentleman who said that he owned the establishment said that he was not going to fix my vehicle, and he no longer wanted me on the property, and I was no longer allowed to come back to that property. I left in the process of leaving. I said, you'll hear from my lawyer. And about that very next day, I immediately started getting the parts that the codes were coming up on my vehicle for the check engine light. I immediately started getting those fixed. And then I as well got the power steering pump fixed on the vehicle. And then fast forward month or two, we went on a COVID shutdown. So I didn't have a reason to drive the vehicle really at that time because I was working from home. But then when May came around and it was time to get registration for this vehicle, the registration was bad. Like I never could get the check engine light off, although I did repair all of the parts to it, the oxygen sensors, the catalytic converters, everything that came up on the code, I fixed, and it still did not take the code off. So I myself again took my car to Dodge out in Stonecrest, and I started trying to find out what was the problem. They said that the problem was the parts that were put on the car were considered aftermarket parts. Got an understanding that Dodge parts are Mopar parts, so it has to be compatible to the Mopar brand. So after that, I still couldn't get the check engine light off. I went and took the what is it called? The emission paperwork that they gave me to go and get the vehicle registration, and I couldn't do that because it had to have a second emission, because by that time that a car was outdated, the paperwork was expired due to the COVID shutdown. They opened up after the date that I think it was May the 18th, if I'm not mistaken. The DMV did not open up to the commissioners didn't open up to after that. So I then I had to go back and try and find out how to fix this vehicle, how to get the vehicle on the road. It started giving me, I contacted the lawyer, and then we started corresponding. My lawyer started corresponding with Pars Cars and Mr. Gregory, and they did a first offer of bringing the car back to the lot, picking out whatever vehicle or getting another vehicle on the lot.
Hold on, Miss Austin, the judge is not part of any plea discussions or negotiations. So any discussions that were had about mediating this, judge is not a part of it.
Okay, so what we did, so am I not allowed to say anything about that part, is what you're saying about the code? Okay, so after let's skip past that. On October the 21st, I spoke with a young lady at the financing company by the name of Stephanie, and she had awared me that I had a payment behind. I awared her that I had already spoken with someone, letting them know that I had already started some conversation with Pars Cars in regards to my vehicle not passing the ignition. So the agreement with the financing company was that I can make up. They originally told me not to pay anything, but I could not allow myself to get in such a bind. So I offered to at least pay half of that note each month until we can get come to a resolution with Pars Cars. So as of October the 8th, I got a call stating that my account was behind. I paid the full balance. And then on October the 21st, Miss Stephanie called me again, informing me that
Miss Austin, I'm going to stop you for a second.
Mm-hmm.
And try to focus you in on basically the elements of the claim.
So this is a valuable part.
Hold on, man. Hold on. Sounds like you're saying that you were sold a car. The car was not operating to the way that you wanted to operate, and that you had damages as a result of that. Is that fair to say?
No, sir. What would be fair to say is I purchased a vehicle that was sold to a fraudulent inspection that was sold to me.
Hold on. When you use a term like fraudulent, the first question that comes to my mind is, did you take that to the police? Because fraud is a crime.
Yes, I didn't file a police report, but I got knowledge from the police on what section and
okay, ma'am. Let's be direct with each other. Did you attempt to file a police report or not?
Yes, I did.
And did they accept the report or not?
My lawyer advised me otherwise.
Ma'am, your lawyer is not the police. My question did not involve the lawyer. My question involved the police, because you said you used the term fraud.
Mm-hmm.
Fraudulent.
Mm-hmm.
That's a crime.
Yes, sir.
So did you take it to the police and did they accept the case or did they
No.
turn the case down? And it's not fatal to your claim. I'm just asking because I'm going to be here till 9 o'clock at night today if I just sit and listen to everything. So I'm trying to focus you so I can understand what took place.
Okay, may I touch bases on that for you?
First, answer my question, then you can touch all the bases.
No, the police did not take up I didn't complete the police report.
Okay, now what's your basis?
So the reason why I'm saying it in that sense is because if I purchased this vehicle on March the 2nd and the very next day the check engine light came on, there's a problem there. You didn't give me correct paperwork, or the fact why would my check engine light come on to a vehicle that had been sitting on their lot for 2 years prior to me purchasing the vehicle, and then boom, the next day I drive it, the very next day it comes on. Your paperwork that you gave me said that the paperwork that I was given from the dealership stated that they had done a legitimate emission on it and it passed. How is that possible for it to pass if the check engine light comes on the very next day that I possessed this vehicle and this vehicle sat on this lot for 2 years prior to my purchase?
Okay, ma'am, that's what you're supposed to tell me.
Well, that's when you said that you said that I can't use the word fraudulent.
No, I said you used the word fraudulent and I explored whether you had taken the steps that most people normally take.
So I did. I also ended up going through Clean Air to get a waiver to even get my tag.
Did you contact the Attorney General's office in their lemon law section and complain that you, in your opinion, received the vehicle from Pars Cars that was not up to standard?
No.
Did your attorney?
I'm not sure because my attorney did aware me about a lemon law, but I'm not sure. I ended up losing the attorney because the case took so long to go to court. I couldn't afford to pay month after month for this case.
Well, ma'am, and this may be something you need to go to the State Bar of Georgia about. Because attorney doesn't just bill you every month that a file is sitting on their desk. They bill you for work that they're doing on the case. So if you paid that attorney monies and that attorney is not here today, that may be something that you need to take up with State Bar of Georgia. The Attorney General's office put the lemon laws, well, the legislature put the lemon law in place, and the Attorney General's office has been responsible for lemon law for people that are exactly in the situation that you profess to be in. So that you're not out here spending money, you're not out here trying on your own to get recourse or to get compensation because you bought a car from a dealership and you allege that the car, there's something wrong with it. And they keep a database so that they know if it's Pars Cars at 123 Main Street and we have 300 complaints from that one dealership, they can then go in and do what they need to do. But I'm asking you this stuff, ma'am, just because I understand your claim as you stated it, and I'll restate it to you, and you tell me how I'm wrong. You purchased a car from Pars Cars. In your opinion, the next day the car started exhibiting problems. You took it back to Pars Cars, try to get them to do something as it relates to the car, and they didn't do anything. And that you now believe that you are out of funds. Is that correct?
Yes and no.
Okay, go ahead,
A
ma'am.
portion of it is, yes, but I would have not had the gentleman not originally promised me that he would fix my vehicle from Pars Cars, and in my as is sold with warranty, it states that after that the vehicle will not have a warranty unless the salesperson promises in a written and to correct the such defects. That gentleman, Mr. Tony, told me clearly in the text message, I promise we're going to do right by you. I'm going to have them fix your vehicle.
Okay, I understand that. And that's why I brought up the lemon law aspect of it, because you're suing under a contract and you're suing under theory that you were somehow mistreated by the defendant. And I'm trying to get to the mistreatment.
The mistreatment started the next day when my vehicle check engine light came on. I mean, when I corresponded with this gentleman, he could have easily said, hey, your warranty says we don't fix it. He did not say that. He said that he was more than willing to fix it. He promised he's going to fix it. Not only that, when they came and stole my car because I put a case against them, that was not right. I then had to go back and fix things that they disassembled in my vehicle when they had no right to take my vehicle to begin with. And then they said that I was told that the Pars Cars and my financing company is the same two companies. Now, when I spoke in a mediation, I was told that that's not true. So if that's the case, why did Pars Cars come and pick up my car on October the 21st if I no longer had any dealings, or they no longer had any dealings with that particular vehicle? They came and took my vehicle from me. Why would that would have been on United Auto to repossess my vehicle, because that's who I had the contract with. I no longer had that portion with Pars Cars. So why did they come and pick up my vehicle and take it to Pars Cars car lot? It should have been picked up and taken to.
Okay, Miss Austin, again, you're the plaintiff, you have to prove your case. But when you start a question with, why did they do this? Or why did they do that? You're supposed to be telling me.
Because I'm blind to a lot of these, like the gentleman, Mr. John, I've never seen him before. I've never conversed with him before. But I didn't think I had any dealings with Pars Cars. Let me say that after I signed the contract to pay United Auto. United Auto, which is my financing company, awared me that Pars Cars and United Auto are the same company. But when I did the mediation, Mr. Gregory said those are two separate entities. If that is the case, why did Pars Cars come and pick up my vehicle and not United Auto? Because I had the contract with United Auto. I would have been late with United Auto, not Pars Cars.
Ma'am, I'm going to keep answering that question with, I don't know.
So that's what I'm saying. At that point, that was a retaliation against me because I filed against them to take them to court. That's a problem. I miss days of work. My kids miss days of activities because Pars Cars retaliated against me for filing this case. That's a part of my asking for. I miss days from work. I had to pay someone to take me to United Auto 2 days in a row, and then at the second day that they gave me my vehicle back, Pars Cars released my vehicle back to United Auto. All of my things on the inside of my car was destroyed. I put my car is a show car. I do car shows. That's a hobby of mine. And they destroyed it, causing me to miss out on money that I spent to go down to be a part of an event because I could not obtain a tag for this vehicle. Did not obtain from May when I was supposed to be able to get my tag all the way through December the 21st, 2020. I could not obtain a tag because of these issues on the car that originally Pars Cars promised to fix.
Was that promise in writing?
Yeah, it's an Exhibit A. It was not pen to paper. It is from Mr. Tony's cell phone. We sent the business card that shows his number with his information, and we also showed it in the text messages where you see where we're corresponding with each other. And that's in attachment A.
Okay. Anything else, Ms. Austin?
Yes, I in this case, I'm not worried about, I'm not worried about recovery of the 15,000, sir. I am looking for a recovering of the money that I spent into this vehicle and the time that I had to take away and the repair, the damages that were done to my vehicle upon them cars come to obtain my vehicle.
Okay, is that it, Ms. Austin?
That's it, Judge.
Mr. Gregory.
Yes, Your Honor. In the nature of time, Your Honor, would you like me to give you a brief opening statement, or would you like me to go through the evidence and question the plaintiff?
Let me ask this question. I see in the file it says that there was a dismissal that was filed.
Mr. Amos or somebody from Pars Cars went down there and did a motion in my name. And this was after they sent the mediation paperwork. I did not receive it. I until went online.
Miss Austin.
Mm-hmm.
The problem when you interrupt people is that you don't hear the whole story.
Oh, I thought you were asking me a question. I'm sorry.
Number one, I said Mr. Gregory.
Hello?
Oh, Jesus Christ. Sir, hold on.
Your Honor, to my knowledge, I definitely did not make a motion to dismiss, and I don't have any knowledge of that.
I don't recognize the signature. It doesn't look like Miss Austin or anyone else, but it said dismissal by the defendant, which of course, defendant can't dismiss the case without the plaintiff.
I'm sorry, I have no clue. I apologize, Your Honor.
No. That was just what I was just gonna ask. Give me your brief opening, Mr. Gregory.
Yes, Your Honor. So my plaintiff sold, or sorry, my client, the defendant, sold the plaintiff a 10-year-old car with 107,000 miles on it. When they sold it as is. Contemporaneously to the sale, the defendant entered into a finance contract with United Auto Acceptance. Your Honor, United Auto Acceptance is a related finance company. So Pars Cars buys and sells cars, and they finance them through the related finance company. Although Pars Cars had no knowledge of the vehicle having any issues, based on its age and its miles, they contemporaneously outlined the as-is status. They outlined it not only in one place, Your Honor, but the buyer's order, it's crystal clear, bold language. There's a separate as-is statement where it's crystal clear, bold language. The buyer's guide, which is the federal buyer's guide, same thing. There's also a vehicle mechanical condition, which states the defendant's going to fix anything after the fact. The plaintiff was expressly warned of even the issues that she brings up in the buyer's guide. It gives you specific, or it shows buyers the specific items that can go wrong. The plaintiff failed to mitigate her damages by she failed to have the vehicle inspected. She didn't do anything prior to committing to the paperwork and the contracts. The vehicle was sold on 3/3 with a Georgia temporary operating permit, the temporary tags that go on the back of the vehicle. Those operating permits in Georgia are good for 45 days. The plaintiff continually says that she was not legally able to drive her car, but that's just not true. Shortly thereafter, on 3/30/2020, so 27 days after the sale to the plaintiff, Pars Cars filed through the Georgia DMV on the electronic titling system, which is mandatory for car dealers. They filed the title. There's a separate document in all the titling or on all the contracts that the plaintiff signed that says that the dealer is only getting the title for the car, not the tag, and that it's the customer's responsibility to get the tag. When this vehicle was sold, the car had a valid emissions. Par's cars got an emissions in May of 2019, and in Georgia, emissions are good for 1 year. So it was good until May of 2020. The plaintiff could have gone into the Georgia DMV at any point after 5/30/2020 to get her permanent tag, with that emissions being valid. The plaintiff alleges the vehicle could not be legally driven, yet she drove it over 28,000 miles in less than 2 years. The defendant nor its agents failed to disclose any material fact known to the defendant. The defendant did not intend to deceive the plaintiff. The plaintiff failed to allow the defendant to inspect the vehicle after the single time that she brought the vehicle in, and she got super upset because they weren't fixing the car quick enough. After that, at no point was she willing to bring the vehicle back in to have them inspect the vehicle. Although my client did not owe any contractual obligation to fix the car, my client is a good car dealer and desires to keep happy customers and potentially could have done a goodwill repair. The plaintiff failed. At some point in October, the related finance company, due to lack of payments, put out a repossession order. The vehicle was repossessed. The plaintiff's attorney at that time contacted me. The plaintiff's attorney was told that if she made her payments, that we would give back the car. We even waived the repossession fees, and the plaintiff was given back her car after she made the payment. The vehicle was never in the possession of the defendant. It was in the possession of United Auto Acceptance, the lien holder. Although United Auto Acceptance is a closely related entity, it is a separate entity and it has separate lots. The vehicle was repossessed by a third party that was hired by United Auto. The plaintiff failed to ever disclose that she did a great deal of modifications to the vehicle. In all the goodwill discussions, that was never disclosed, but the vehicle has had tons and tons of modification: electrical, mechanical, cosmetic, so on and so forth. If the plaintiff suffered any damage or losses, such damage or losses were caused in whole or in part by the plaintiff's own contact, not the acts or omissions of my client. The plaintiff sold the vehicle to a third party at some point this year. The vehicle was paid off by a used car dealer, likely as a trade-in. Thank you, Your Honor.
Thank you. Ms. Austin, this case on a contract basis, Par's Cars wins. I mean, under the conditions, under the contract, as the car was purchased, they win. Now, to the extent that you allege that there's something that's going on, that you were sold a quote unquote lemon, that goes to the Attorney General's office. And that's where you would, if there is a case there, that's what you would obtain satisfaction. But at this stage, based upon the fact that car is purchased on an as-is basis, and there's no allegation that there was an overt attempt to defraud the customer.
May I say something?
Ma'am, yes, ma'am. But please let me finish talking. Absent evidence that there is an overt act to defraud you as the consumer, I can't pierce that contract. But if you believe that there's something that was done, you can go through the Attorney General's office and their section that deals with lemon laws. Now, yes, ma'am, please.
So how can I obtain a tag when the city is closed?
The whole city was closed for COVID. There was no way that I could get a tag in between February or May because the city was closed. And when the city opened up, that paperwork was expired. They said they could, the commissioner's office said that I couldn't do anything. I could not get a tag because the paperwork was stated for May 15, 2019. I can't make the city be open in that time where I was supposed to obtain that tag. And actually, I wouldn't have been able to get a tag prior to because the check engine light came on the very next day. But you said that I need to go through the Attorney General's office and file for or find out about the lemon law.
There, you can Google it right now if you want to. But again, Miss Austin, and it's like you asked the same question 10 different ways.
No, I mean, because it's logical. It's common sense. I cannot obtain a tag to a city that's closed for COVID. It's not my fault the city closed down and then when it opened up, the paperwork was expired. I have proof of that. But it's as if my proof doesn't matter. So what I lose either way it go. Only way I would have won is if the city would not have shut down prior to this this paperwork expiring. And even if then, I should have still been able to take my car to an admissions, pass it, because it ain't even 6 months that I've had the vehicle that I couldn't even pass admission.
Miss Austin, may I respond? Will you allow me to
respond
to your initial question?
Mm-hmm.
My understanding is that they extended the deadlines as it relates to.
No, sir. I got the paperwork. Can I email it to you?
Ma'am. Again, in court, one person speaks, the other persons listen. Then there's a response. But it's not a back and forth.
No, sir. I got the paperwork. Can I email it to you?
Someone who apparently is on YouTube. So, ma'am, if I'm wrong, I'm wrong. I don't understand the admissions aspect of how it relates to this case, but you can feel free to send whatever you want to send in, and I will take a look at it. Okay, ma'am? Mr. Gregory, I'm going to need you to submit me a proposed order or judgment form. It can be on the basic judgment form dismissing this matter against your client.
So do I have the right to appeal? Because I feel like you weren't, no. Do I have the right to appeal?
Ma'am, allow me to answer your question before you start moving on. You don't have to justify your question to me or anyone. Yes, you do have the right to appeal. And you can appeal to the State Court of Clayton County. And if they want to take the case, they'll take the case. Mr. Holmes, I'm coming to you next, and Ms. Lowe and King's Automotive, I'm going to deal with you. Mr. Holmes, this should be short. Mr. Gregory, you send that order over and we'll get it signed. Ms. Austin, you are excused.
Thank you.
Mr. Holmes, this is a vehicle forfeiture, correct?
Yes.
Now, have you complied with all of the statutory duties?
Yeah, yeah.
Hold on a second.
Hello?
But the answer that was filed says that the vehicle was repossessed by a finance company in 2018.
Not.
I'm sorry, sir?
It was not. Now they did come out. They sent someone out, but the driver left the vehicle due to the condition it was in.
When you say they sent someone out, can you explain that to me, sir?
A tow truck driver came out.
I need a full story, sir.
Well, the tow truck driver came out to retrieve the vehicle, but
From where? From where?
From the finance company, I believe. That's the only place it could have been.
And how are you seeking to recover this vehicle if it was with the finance company?
No, it was with me. It's been with me the whole time.
How did it get from your possession to the finance company?
It never left my possession.
Okay, let's start this all over again. I heard you say they sent someone out to get the vehicle.
Yes.
That was at the finance company.
Right.
How did it get from your yard to the finance company?
They never got it. He left it to the amount of damage.
Sir,
Okay,
come
I'm
on.
listening.
How did it get from your possession to the finance company?
It never left my possession.
So why did they send someone out to the finance company to pick up the vehicle?
If there's somebody picked the vehicle up, they was gonna have to pay me for the vehicle. They didn't pick it up. They didn't leave with it.
They didn't leave your
establishment with the vehicle.
So when you say they sent someone out to the finance company,
No, they sent someone out. No, they sent someone out to me.
To you.
Yeah.
And you refused to return the vehicle.
They didn't take the vehicle. They didn't attempt to take it. They came out to, but due to the amount of damage on the vehicle, I guess they decided not to. The vehicle is a total wreck.
How long has the vehicle been in your possession?
Approximately 4 years.
And is there a reason you didn't turn the vehicle over to the finance company?
No, I want them to come and get the vehicle. I want to be paid for it. I wish they had got it.
Okay. I'll tell you what, Mr. Holmes, I'm going to ask you to submit me a proposed judgment form. And I'm going to take a look at it, and I'm going to take a look into this.
Okay.
And that'll give me time to do that while I'm not holding up the whole calendar, because I'm almost 30 minutes behind right now.
Okay.
So, sir, you're going to have to send that in to my office so that I can take a look at it. And in the meantime, I'm going to take a look deeper into this. Because I just want to make sure that everything is being followed under the statute as it relates to abandoned motor vehicles. Did you publish the fact that you were attempting to do this?
Yes.
Okay. And the answer, essentially, the owner of the vehicle is saying they don't even have the vehicle and that it was repossessed by the finance company.
The owner left the vehicle with me, the actual owner, because it was too much for them to repair. The cost was too high, so they just left it.
Okay. All right, Mr. Holmes, you get that information into my office and we'll deal with it. You've been very patient, sir, and I'm not gonna hold you any longer. I'm gonna call you can go, Mr. Holmes.
Okay.
I'm gonna call the last case on today's calendar, the morning's calendar, which is Alexia Lowe versus King's Automotive. Ms. Lowe, are you ready to go?
I am. I apologize.
Okay. King's Automotive, are you ready to go?
Yes.
Okay, it's going to be position 1 on this morning's 8:30 calendar. Alexia Lowe versus King's Automotive. Ms. Lowe, I'm going to need you to turn on your camera. All right, Ms. Lowe, and what's your name, ma'am, from King's Automotive?
Sarah.
I'm sorry, what's the last name?
Sarah. Elliott.
Elliott. Okay, Miss Elliott and Miss Lowe, would you please raise your right hand for me, please? Do you swear affirm the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay. Miss Lowe, tell me what this case is about and why it's the ruling in favor.
Okay, so back in 2019 of November, I bought a car. I'm sorry for the outside noise, by the way, but I never drove the car off the lot and I couldn't test drive it because it needed a battery. I paid for the car that day of $2,500 because I was told that certain parts needed to be ordered. This is my first time buying a car, so I never knew to test drive anything or like anything. So I was just buying a car. I was told included in that payment would be my tints on the windows, the tires, the cleaning of the car, the new battery, a radio, and all that came up to $2,500. I asked about the car within like weeks timing. It even got to a point where I had to ask my family for rides and stuff. It took 4 weeks for me to try to receive the car. At that point, I went ahead and asked for a refund. I was denied my refund. I also came up there with the police December 10th through the 13th, asking for my refund of 2019. I finally went ahead and did the civil suit and won back in 2020 of February. Then COVID hit, and I guess they tried to pay for the appeal back before COVID hit, but they couldn't pay for it until after COVID, which was a year later. But prior to that, I spoke to Mr. King, which is Miss Sarah Elliott's husband. I spoke to him on the 14th of December of 2020, asking him about the payment arrangements, and he told me he would be able to pay me through PayPal or Cash App. But when I came up there with the police, he said that they're appealing the case or whatnot. So then I didn't hear anything except through the courts after.
Let me ask you this question, Ms. Lowe, because I did see the appeal in the procedural history. What was the result that there was an appeal filed? What was the result of the appeal?
That I was able to get my money back plus the court fees.
Okay. And so are we here to get a new judgment?
They're actually not trying to pay me. I'm here because I went up there to collect my money from them, and they were saying that they were putting an appeal in, and then COVID hit, so it allowed them to take more time on paying me back. But Mr. King, who I actually did work with, he was actually willing to do payments with me through PayPal or Cash App. But when I came up there that day for the payments with the police, he was saying that he no longer agreed to those terms and that they were going to go through with their appeal. Once the appeal did happen, which is now happening because I missed a court date, and that was due to not having a transportation of car. I am asking for some money back towards the paying people in Ubers and stuff, which I have documentation. I paid over $1,000 within the last 3 years. I'm finally just now getting the car. So I'm just asking for my money back from the refund that I already won the first time. And I'm asking for my court fees.
Ms. Lowe, let me stop you because this was a thing that was confusing to me. When the case was appealed, what court did it go to?
I was calling down to Clayton County the whole time. I'm just getting information from them.
Hold on. So your answer is you don't know?
No.
Okay. Miss, I'm sorry, ma'am. I should have written it in. Tell me your name again.
Miss Elliott.
Miss Elliott. Miss Elliott, what court did you appeal to?
Let me get back to my document. I'm in my part. You're gonna have to give me a minute. Let me get back to my paperwork.
There's, because I saw in the file that there was an order issued by Judge George for clarification, but it doesn't really say anything other than clarification. So I'm trying to figure out if this is even
to my paperwork.
proper before. And for everyone who logged in at 1:30, I'm sorry. I'm going to try to get to you as quickly as possible. I'm going to ask if there are any parties as we're moving forward that want to not resolve, but at least meet with the other side to see if a resolution is possible. I will allow that to happen. Hearings generally are, I have to follow the law as it relates to the hearing.
It looks like it was filed in the magistrate court.
I mean, it said appeal magistrate, and I guess that's a new one on me. Magistrate court sitting as a trier of fact and determining whether an error was made on appeal. So from my reading of the file, this is a situation where there needs to just be an order entered into. That was done before.
But we appealed the third. Sorry, go ahead.
No, you're breaking up.
I hear somebody else talking.
I know we got from Ashley McLaughlin. There's some backlog or feedback. So, what was the result of the appeal, to your understanding?
To be honest with you, Judge, it has been some time that has gone by, so I can't recall everything in its extent. However, we did appeal. We did remediation. At the time, we were in-house doing the remediation, and there was no resolution. So we just appealed, basically stating, so we can go before the judge, because we didn't come to an agreement. But
according to this, it says that that the two of you appeared before me on August 3rd of 2021.
If I may say something?
Yes. Oh, Miss Elliott, ma'am, you cannot drive.
Oh, okay.
During this, you are legally or literally committing a crime that's being recorded.
Okay.
So I'm sorry, Ms. Lowe, I interrupted you.
I was just trying to say that, yes, you're correct about we were appearing before you of 2021, but that's when I wrote a letter to you because I missed that court date.
Yes.
Yes, I missed that court date due to not having transportation and losing my job when I was trying to buy this car from them. And I lost my job and I had put my family in a hotel. So at that point, my phone bill, I couldn't keep no bills consistent because I had a newborn baby and I wasn't able to do anything. And then they played with my money, so I couldn't get no car or anything else. And I didn't have family to help me.
So most likely the effect of that hearing was I dismissed it for want of prosecution. It says here that there was a judgment entered for $3,100 plus court costs of $100 on February 28th of 2020. And it was against King's Automotive. And I think,
if I may add something else, Judge, I just was trying to also get back the transportation money it cost me to try and get my car at the timing of the purchase. I know that it stated in the beginning 3,100 is what was asked for back, but I am I couldn't upload the information and the forms on the link that they provided me with, but I do have screenshots of information if you would like of how much I paid over the timing span of just transportation alone, not hotel money, not anything from how everything trickled down after COVID, but just off of my transportation fees. I have over 1,000.
Okay. This is what I'm going to do. I'm going to reinstate the judgment that was issued on February 28th of 2020 for $3,100 plus $100 and court costs. Ms. Lowe, you may be entitled to post-judgment interest. I'm not sure. You're probably going to need to speak to somebody about that. But Judge George heard this then, and I'm going to follow her judgment from February.
You have a right to appeal.
I'm sorry, ma'am?
You have a right to appeal.
Yes, ma'am.
Yes.
Okay. Is there anything else?
How many times do you get to appeal a case? Like,
you get to appeal a judgment. So it's a judgment or a ruling. You get to appeal it. So there's no.
And then I would have to keep bringing the same case back up. I'm sorry to interrupt. I would have to bring the same case back up to you again.
That depends on what happens with the appeal. I can't predict the future. I can only tell you what the rules are.
Okay, and this wasn't the appeal.
No.
Wow. Okay.
I believe, just so I can have it correct, the time that we were to appear before you, that appeal, she missed that court date. So we're kind of redoing. So basically, you reinstated the judgment.
I placed
because
it
she
back.
missed the court date.
No, it's not
Go ahead.
because she missed the court date. It's within the discretion of the court to grant or place a case back on the calendar. And because of the reasons that were given, I placed it back on the calendar or asked for it to be placed back on the calendar. Okay. All right, ma'am. Miss Elliott, Miss Lowe. Yes, ma'am.
Just to confirm, going forward, my next step is to wait. I apologize. My next step is to wait 30 days to see if they appeal or not.
That's when their statutory period to appeal runs out, but you're in a whole new ballpark. Because just because you got a judgment, it doesn't mean that you're gonna get a check written to you. There's collections and post-judgment relief and all kind of things that you have to
Obtain first.
educate yourself about. Yes, ma'am.
Okay, so going forward right now, after this, like, how do I collect my funds?
You're who?
Like, how do I collect my refund back? Like, if they don't put the appeal in?
That's the whole post-judgment collection thing. All I can give you is a piece of paper that says that you're owed money. It's up to you to figure out how to turn that piece of paper into money.
I got you. That's understood.
Okay. All right. So you are free to go, Ms. Lowe. Ms. King, you're free to go.
Thank you for your time, Judge.
Thank you. For the rest of you, it feels like I have cotton balls in my mouth. I'm gonna take me a second to get some juice and then I'm gonna come right back.